Welcome to EMBARGOED, intelligent talk about sanctions, export controls, and international trade. For trade nerds and normal human beings alike. I'm one of your hosts, Tim O'Toole, and with me today is my friend, colleague, co-host, and international trade legend, Doug Jacobson of the law firm of Jacobson Burton Kelley. Doug, it's really great to have you on the podcast. Thanks for being here.
All right. Well, thanks, Tim. Glad to be here. And I don't think this is an emergency podcast, but some people do think it's an emergency.
Yeah, it's actually a big emergency in China, and fortunately, we're gonna break some news today. Although we're not obviously going to release this live, it sounds like just before we got on to record on Friday afternoon, the Commerce Department came out with some FAQs. So just to set the stage, we're going to spend today talking almost entirely about some actions that the Commerce Department took on October 13th, 2022 with respect to China.
Actually October 7th.
October 7th. Oh. So
the date that will live in infamy.
Exactly. Well, so one of those actions related to the unverified list, and then there was a much more prominent, or at least it got a lot more press, action that related to a certain advanced computing integrated circuits, so basically supercomputer chips and manufacturing equipment that would allow for these types of semiconductors and that sort of thing in China. And so, Doug, why don't you kind of just set the stage for what happened with the Commerce Department? Tell us a little bit about first the UVL actions, the unverified list actions, and then we'll turn to the super chips.
Yes. So there's a lot to unpack, and it's been a very busy 3 weeks since this rule. It's hard to believe it's only been 3 weeks, but it's been nonstop. And I can tell you from a practical practitioner level that it's really taken this long, and it's going to take longer for companies to still figure this out. And companies are still figuring this out. But let's talk about the two separate rules. So, because it is, I think, important to understand both of them. And there has been some, I believe, misinformation. I will also call it unnecessary hysteria regarding both of these rules. And so it is very important just to take a step back and really understand what this is all about and what actions were actually taken. So let's first talk about the unverified list rule. So it is confusing because these rules were, and BIS has been doing this for the last 3 years or so, where they will issue a interim final rule like this one, or a final rule, and it becomes effective on the date it's published not in the Federal Register, like a normal rule, but actually in the pre-publication website that is hosted by the Federal Register itself. So this is very confusing, and I have talked to BIS about this. I believe that there may be some administrative legal issues as to the validity of these pre-publication effective dates.
Might be a little bit of a false start. They jumped the gun a little bit on the effective date when by essentially making it effective before it's published.
Well, right. They actually get a head start because it's effective immediately on publication, but it's not in the Federal Register, which is the actual official government gazette, which is what's supposed to be giving people public notice of a. And I've done some research. I can't find any other agency in the U.S. government that takes this position. BIS swears that they have legal support from the Federal Register, that this is compliant. They do take the position that, of course, a final rule or interim final rule can be published without a proposed rule under the Administrative Procedures Act because it is national security based. So they can, I understand that, but still I have no problem if it's effective on October 13th, but they're making the effective date October 7th, and in fact, the second rule we're going to talk about was even more complicated because it had 3 separate effective dates, October 7th, October 21st, and then one in the middle. But let's talk about the unverified list. So those who are listening in, who may be sanctions practitioners, are well aware of the SDN list. We all know about the SDN list. I'm not going to say we know and love it. We can know and hate it because it's a big list. The unverified list is probably the smallest of the lists that we all look at. And the unverified list, unlike the SDN list on the OFAC side or on the entity list at the BIS level, is not a prohibition. And this is one key point for people to remember. The unverified list is simply a list of companies where the Bureau of Industry and Security, BIS, has not been able to conduct a post-shipment verification or pre-license check, or has some concerns about the bona fides or legitimacy of that particular company. So for example, a company submits a license application, a US company submits a license application. BIS is going to look at that company. Well, BIS does what we all do in terms of due diligence. They're going to use their own resources, but they will use just basic off-the-shelf things like Google Earth, and they'll do a review. And if it has some sort of a number in Hong Kong or wherever it is that looks a little bit like an apartment number, and they do a Google Earth review, and you hone in on it, and it could be an office building or whatever, but they are well aware that particularly in Asia and other places that you have these front companies that basically is just, I've been to many of these in Asia as well. You go into the door and there's like 30 different names on the outside of the door. Now, that is obviously a red flag. And that's what the unverified list is. It's a red flag. And so what it does is it does not prohibit or require a license if a license is normally not necessary. But what it basically does, there are 3 implications. The first one is the most important, which is that before an exporter or re-exporter can ship goods to this party on the unverified list, they have to receive a statement called the unverified list. It's like an in-use statement, but it's simply just a document, and the requirements are in the EAR itself, and it's basically just the company who you are shipping to must sign this unverified list statement and certify that the goods that they are receiving will in fact be used by them for the stated purpose, and they will not otherwise divert them, and that they will cooperate with any in-use checks that the Bureau of Industry and Security may choose to do in the future. That's no different than any other transaction that's subject to the EAR. So all you have to do is get this piece of paper in writing prior to shipping. And once you have that, you're good to go. Of course, you need to determine whether there's a license requirement as well. So it doesn't mean that you can't ship. It doesn't mean you need a license. It just means that you need to get this piece of paper. The other 2 issues is you cannot use a license exception to ship to a party on the unverified list. Now, again, that may be license exception RPL or one of the ENC or one of the other. So you can't use a license exception. And the third one only would apply to a US exporter, which is that you have to file an electronic export information, the EEI, for all exports, regardless of the value, and regardless of whether it's NLR, for example, no license required, to that particular customer. That wouldn't apply to a non-US re-exporter because there's no EEI filing requirement since it's not being exported from the United States.
So it's a little harder to export to somebody on the UVL, but not
It's
not
a
a
little
license
harder, but it doesn't mean, but not a license requirement. And again, it's a red flag. Now, some companies, I have clients who are very, they're very cautious, and they'll say, well, should I ship to them? Well, my answer is, well, as long as there's no other reason to believe or some other information that that there's some problem or they're not a legitimate customer, go ahead and ship, is my view. So there's a company that was added to the in China called Wuxi Biologics that was added to the Unverified list late last year. I believe it was December. And Wuxi Biologics is a publicly traded company in China. It's a big company in China. And there was a lot of misinformation and their stock price went down because it was viewed as being added to the entity list, like Huawei, for example. But it wasn't like Huawei. So some U.S. companies did choose to hold off on their shipments. But the problem right now in China is that because of the zero COVID policy, and that there's only really one BIS staff member in Beijing who can do these end-use checks, it's difficult from a timing perspective for BIS to do these particular end-use checks. So it wasn't that Wuxi was being uncooperative per se. It was the bottom line is that MOFCOM in China has to go with the BIS staff to visit the facility. That's China's requirement. I call them minders or babysitters. That's not a requirement in many other countries. And if MOFCOM can't travel because of zero COVID or for whatever reason, then they can't conduct the end-use check. So that gets back to, on October 7th, BIS added 31 new companies in China to the unverified list. And so there were a number of universities, there are a number of companies here, some institutes, some Chinese academies, for example, of geological science. But the biggest company that was named on here is a company called Yangtze Memory Technologies Company, YMTC. So we'll just call them YMTC. And there's been a lot of discussion about YMTC. So there's been a number of efforts by various organizations to put pressure on BIS to add YMTC to the entity list. YMTC provides memory chips. They sell to Apple, for example. Apple is a big, their supply. And these are advanced memory technologies that are going to go, in your phone as well as other applications. And so YMTC was the company that was, a lot of people said, woo, they're on the unverified list. Well, again, it doesn't prohibit exports to YMTC. It just triggers those three requirements that we were just talking about. And then there were media reports that Apple's not going to buy from YMTC or they're putting their relationship on hold, for example. And again, it has nothing to do, this is export controls, nothing to do with Apple's ability to purchase items from YMTC. Even if they were on the entity list, there's no prohibition on buying from Huawei.
That is, in my experience, kind of one huge misconception and what gets confused all the time, because I think you pointed it out perfectly at the beginning. People think of lists and they think of the SDN list. And with the SDN list, obviously, you can't deal with that company at all if you're a U.S. person, unless authorized by OFAC, but their authorizations are rare. With the BIS lists, certainly the entity list, and even more so the unverified list, lots of dealings are allowed even if the company is on the list. There's just certain restrictions, and I think people don't get that. And it's one of the problems from screening too, is that you screen and a lot of screen readers say a hit can't do anything, but lots of hits are different, as we know. Sorry to interrupt. Continue.
And that gets to the point about screening, whether it's even in the OFAC world. You have to understand, the screener who's receiving the list of hits has to understand what the different lists are. And that's a key component of education when you're dealing with restricted party screening. So in terms of the hierarchy from the SDN list or the entity list, the entity list is, again, not necessarily a prohibition. It triggers a license requirement. So getting back to the unverified list issue is that, so these new 31 parties in China, there obviously is a lot of concern. And on the same day, so there was nothing that unusual or interesting about this unverified list. In fact, on that same day, in that same rule, one of the two WuXi Biologics entities was removed from the unverified list. So that same rule actually removed a number of companies in China from the unverified list. So they do this periodically. They add, they remove, because in this case, this particular WuXi Biologics, they actually had, I had heard through reliable sources that the in-use check was done last June, but it took them until October to remove them from the list. There is one other WuXi Biologics entity that they haven't been able to review yet, but that will be probably done, in the coming months. So the other thing before we move on to the advanced computing rule, the other interesting thing that happened on October 7th as it relates to the unverified list, and this has also caused, I believe, an unnecessary, there's been a lot of misinformation or hysteria about this, that the Office of Export Enforcement issued a memorandum. So Matt Axelrod, who's now the Deputy Assistant Secretary for Export Enforcement within the Office of Export Enforcement within BIS, he issued a new policy regarding the unverified list. And what this new policy does is that it does put pressure on the foreign governments to be cooperative in the effort to remove parties from the unverified list. It wasn't targeting the companies per se, but it was really focused on the Chinese government or other governments who may not be cooperative.
Right. And I'm glad you pointed that out, because I think, we can talk about this a little bit more, but it's kind of a nice segue into the advanced computing regulations. I do think there was a clear sense, as I read the justification for the rule, that this is really about the Chinese government, that this is really a message, to me anyway, that BIS wants the Chinese government to be more cooperative in end use and end user checks, and to the extent that it's not, it's going to start using the unverified list as a way to essentially interfere with the ability of these companies to easily export or to easily receive U.S. technology in terms of export and U.S. products in terms of export.
In fact, if you look at the memo, which you can find on the BIS website, and the subject of this memo is addressing foreign government prevention of end-use checks. So it's not focused on the companies, it's focused on the government, because so it says, most foreign governments eager to receive U.S. exports welcome our end-use checks and work to assist us with them. When a foreign government prevents an end-use check from being completed, we are denied visibility. When such a situation arises, we will try to work with the foreign government, but a foreign government can prevent BIS from and undermine what BIS is trying to do. So what they are doing here is they announced this new policy, which can basically have a negative impact on the parties on the unverified list if the Chinese government, let's just call it what it is here.
Right.
It's the
Right. They call
government.
it foreign governments, but this is clearly aimed at China.
Yes, exactly. So the idea here is basically what they said is that they're implementing this new, they call it the two-step. So this is not the Texas two-step, but this is the BIS Office of Export Enforcement two-step. And the new two-step is basically saying that if the company and the government do not cooperate after 60 days, we can then start the process of adding them to the entity list. Now, again, the entity list is the hammer. And that's the hammer that's been successfully hammered Huawei, for example. and others in China and around other countries. I mean, I represent companies who've been added to the entity list all the time, trying to get them off of the entity list. Sometimes there's no off-ramp like Huawei, which is another issue we can talk about. But it's not a guarantee. It's not that this is some 60-day clock that is ticking, that is going to all of a sudden after 60 days, we're going to see another list come out adding these parties to the entity list. That is just not how it works. And in fact, there's a standard for adding parties to the entity list. It is an interagency process. It's not just BIS or the undersecretary waking up. We want to add this particular party to the entity list. There is a process. So this has been another part of the miscommunication. Again, I do believe that if a company is on the unverified list and they want to work cooperatively with BIS, and that there is a delay not caused by them, but it's caused by the government, BIS can reach out to MOFCOM and try to figure out what the problem is. But they're trying to put the pressure on MOFCOM here to cooperate. So again, I just would recommend your listeners here, take a deep breath, understand, reach out to counsel, discuss what the implications here are. But it doesn't mean that your customer who's on the unverified list is going to be on the entity list in 60 days or even 90 days.
It's just a warning. And one thing that they being the Commerce Department, is trying to use to scare the Chinese government or foreign governments into more cooperation with end-use checks.
Exactly. And the memo is clear. I mean, it says, upon successful completion of an end-use check with favorable results, export enforcement will initiate the process to remove that party from the unverified list or entity list, depending on which list they are on at the time of the end-use check. So again, it's just another tool in the OEE arsenal that they can use to put pressure on these parties.
And so with that, I mean, I think part of the reason that I think that this is a little bit related is when you turn to these new rules that came out with respect to the advanced chips and the advanced chip manufacturing equipment, at least as I read the 128 pages that BIS did in terms of justifying this, I mean, one thing that jumped out at me was that there was essentially a complaint, and this in particular with the U.S. person provisions, I saw this, but even more globally, that BIS is not getting a lot of visibility into how these sorts of items for export are being used in China, and it fears that they're being used by the Chinese military. And so part of the motivation driving this was that even though there may be many civilian uses for these sorts of items, and they might be largely used in the civilian portion of China, the fear that they might be used by the military, when combined with this lack of visibility, it seems to me to at least be one of the major drivers for this rule, just as it was for a driver for the changes to the unverified list.
Yeah, that's exactly right. I mean, it is clear if you read. So the good news is that the rule that you're referring to, so on October 7th, when it came out, it was 130 pages. When it was published in the Federal Register, which is using 3-column, much smaller font, that is the normal Federal Register font, it only ended up being 30 something pages. So it's obviously it's actually 30 pages. So it's only 30 pages. So that was much easier.
Single spaced, teeny little fine print.
Single spaced, 10-point font or whatever they use. No, exactly. And again, and there's lots of moving parts. This is one of the most complex. I mean, I've been doing this for 32 years now, and I've seen some complicated rules. But this is complicated because it has it's capturing many different aspects. It's covering very specific technology. But you're right, to your point. Again, this is from a big picture, from the policy perspective, this is what BIS is trying to capture, which is, again, the use of advanced computing to assist the government of China in military applications, as well as other potentially problematic applications, such as human rights abuses. So they're focusing, for example, on Xinjiang region, which is because AI can be used by Hikvisions of the world with respect to cameras and identification, and that's been very well documented, and that's another focus. Now that gets to the point of a lot of people called this at the beginning the AI hoop. This is focusing on artificial intelligence, but that's not really the case. Artificial intelligence is only mentioned twice in this rule, and artificial intelligence is a very, very broad, it captures everything from your most basic iPhone giving you a prompt in your text message, what to predicting. That's AI,
right?
Really. That's a computer learning what your proposed response to your text message would be, yes or no, or I'm not available, or whatever, up to the most advanced functions and facial recognition and the like.
Great. Well,
so do you want to go through the? I've kind of I've had some clients. It's funny. They want to obviously executives and companies aren't going to read 30 pages single spaced, and so companies want to have this distilled. And I've tried to distill this down as much as possible, and I can only get it into a few pages. But what I have been able to do is to organize this into basically 5 separate buckets, or if you will, of areas that I think make it more useful for companies trying to figure out the implications to them.
Yeah, no, I'd be really curious to hear the 5 buckets, because this rule just seems to go off on, there's 2 topics, but it goes off in multiple directions on those topics. So I'd be curious to hear how you can get this down to 5. And so let's walk through them.
And I think it's clearly. I think this is. I've seen anywhere between 4 and 6 categories. Because there are now 3 separate foreign direct product rules. But let me give you my 5 categories. Okay. So the first one, and again, they all apply to different companies and different applications. So the first one is a new series of ECCNs, or export controls, on certain hardware that can be used in semiconductor manufacturing. Some of these were already captured in other ECCNs, but they have this new, the main category is new ECCN 3A090. There's also 4A090, which is confusing because that talks about computers, but it basically refers back to
it's just computers with the chips in it.
Correct. So this is again stepping back at what this is intended to do. It's intending to only address advanced computing and supercomputing. It's not intended to capture functionalities that may be used for automotive function applications and legacy, more mundane items that semiconductors are used in. So if you look at 3A090, now 3A090 does impose a new specific regional RS control that is for China and for
the listeners who may not be versed in the RS is regional stability, which existed.
Regional stability, which is not very often used, but regional stability as a reason for control. So if you look in the Commerce Control List, you see 3A090. It gives you the reasons for control. And then if you go on to the Commerce Country Chart in RS Category 1, China is going to be there. So it's clear this is China, but it also does apply to the embargoed countries because it's also controlled for anti-terrorism or AT purposes as well. But again, this is essentially a China rule. So this 3A090, there are several technologies that are specified which are covered. And when you go through these are very, very high-end integrated circuits. Let's just call them chips. So these ICs or chips that are covered are super advanced. At least today they are. In 2 or 3 years, they may not be. That's another issue that we can talk about. But these ICs, when you go through these, they have very fast bidirectional transfer rates. They have very high performance that is measured in this term that's used throughout the EAR and called TOPS, number of operations per second, for example. And these are very, very, very fast, most advanced chips. And so these new controls, and I don't want to discount this, but I don't want to overstate this. It is focused on the most advanced technologies. So I do have some clients who are affected, but many clients are not impacted by this. So this is this new, these new RS controls. This is the first category, are these new ECCNs and controls.
And they just,
so again, that will apply.
And I was just going to follow up on your point. The ECCN lays out technical parameters for these chips that are extremely detailed, so that they know it's clear that their engineers knew exactly what they were aiming for and tried to create an ECCN that caught that and only that.
And it shouldn't, in a company, there shouldn't be any gray area in terms of what's covered. Now, if there is a gray area, you can always submit a commodity classification to verify as a protective measure, for example, to verify that you're not in 3A090 or 4A090, for example. So this first group of controls, again, applies to the items themselves and applies to the export or re-export of those items. So that's the first new sets of controls. Again, relatively narrow to these advanced chips. So the second area has gotten a lot of publicity, and this is these new controls on semiconductor, on certain end uses. So the end use controls are on, it's if you have one of these new certain ICs, if you know they're going to be used in the production or development or manufacture of a supercomputer located in China or destined for China. So this is basically the second category of what I'm calling these new in-use restrictions by US companies and items that are actually subject to the EAR, not impacted by the foreign direct product rule, which is a whole separate analysis.
So
these are items that are actually,
and these are this is the new regulation in 744.23 that you're talking about at this point.
Correct.
It basically sets up a new, if you know that your item that you're exporting is going to be used for this purpose, the semi-computing purpose, and again, pretty well defined in China, you need to get a license, basically.
Correct. So these end uses, there's three end uses. One is supercomputing end uses, which is now a defined term in Part 772, and it's a very, very, very high, very specific definition of, and I do not believe, I have not verified this or heard anybody who's at, but I don't believe that there's actually a computer in China today that meets that definition. Now, obviously, they're trying to focus on, they probably chose the most high. I've heard that maybe there's 1 or 2 computers in the United States that meet this definition. But obviously, they're trying to limit and impede China's ability to build these same types of supercomputers. So the end-use restriction is the second bucket, and there are the 3 end-use restrictions. One is on the supercomputing. The The second are these advanced end uses. And these are what I've been calling the A, B, and C end uses. And we've heard these are the most current technologies, which are certain logic ICs that have a production node of 16 or 14 nanometers or less. Certain NAND memory integrated circuits that has this 128 node requirement, and certain DRAMs. So if you look in the final rule, you will see these logic IC, NAND, and DRAM parameters referred to throughout. And I call these the A, B, and C end uses. I think it's the easiest way to look at them, because then you can say, because they're referred to in many sections, and this is one of the more confusing parts of the rule. It's also in the US person rule that we'll talk about in a minute. But if you think about these A, B, and C end uses as the advanced applications that they're trying to cover, as well as supercomputers, then it makes it a little bit more clear.
Great.
That makes sense?
Yeah, no, that makes perfect sense. And I think it really is just kind of driving home the point that there were a lot of engineers involved in writing this rule. And that is one.
No, exactly. Right. And it was intended to be, they were trying to carve out a particular subset of technology.
Yep.
So again, in our second bucket, we have the supercomputers, we have the A, B, and C advanced technologies, and then the third is any item subject to the AR if you know it's going to be used in the production or manufacture of certain ECCNs in category 3B. Now, what is category 3B? This is semiconductor manufacturing equipment. So that's the third restricted in use that we have. So one of the key points here, and this is a key kind of a practical takeaway to the audience, which is I've been spending a lot of time with clients over the last 3 weeks. Well, how can you determine your customer's end use? The only way to do that is to get some statement and some evidence in writing. Now, many companies get end use statements, and as a matter of practice, this is something that you have no choice, in my view, because it talks about knowledge or if you don't have knowledge. Well, the only way that you're not going to have knowledge is if you don't ask the question. If you ask the question, do you or do you not will you use my hardware or software in the production of these three applications? So that's where I have modified clients' end use statements, because this is really essential that you need to know.
Yeah, absolutely. And I mean, I think there are a number of these end use and end user requirements in 744. And if you are operating in that territory, you really do need to get an end use statement. You need to get an end use statement that is believable. I mean, that's the other thing that I talk a lot about with clients. If, one, you've got to get one, and it's got to be a real end use statement. But is there anything else about what you're doing that if BIS came back later and said, you got this statement, but how could you possibly rely on it? Are there any other facts out there that you've seen that don't add up? Because if you just get the end use statement, but it's not one that's reasonable to rely on, you might as well not get it at all.
Well, that's always the challenge in end use statements. Yep. I mean, again, anybody is willing to sign anything. Some people will say, well, how useful is this piece of paper if I can't trust it? Well, that's obviously would apply to anything. But if you do have some, and most of the companies in this particular sector, in the semiconductor sector, I mean, again, this is a highly technical area. They have to work with their customers. Yep. I've heard that there's only maybe a dozen, or maybe not, less than 20, less than 2 dozen for sure, fabs in China that have the ability to produce these advanced computing applications, for example. So, and people talk, and engineers, and many of these companies have people in China on the ground. And so obviously you can't self-blind or put your head in the sand, or whatever metaphor you want to use. But, if you have no reason to know and you get this piece of paper and they sign it, then, you're going to be, BIS would have a very difficult time, bringing in an enforcement case.
Absolutely. Absolutely. No, they're good protection. And, and I think that's key to the clients being able to comply with this rule.
Exactly. We'll talk about enforcement in a second. But so the third category is there's two new foreign direct product rules that it applies to advanced computing and advanced and supercomputers. So this applies to non-US companies only. So this is, again, if you're a US company, you don't care about the foreign direct product rule, that's your customer's issue. So again, I have clients that are outside of the US, I know you do as well, that this is having to focus on, are they producing items for these A, B, and C end uses, or supercomputing end uses, using US origin controlled hardware and technology, including the 3A090 that we were just talking about as well. So that's the third bucket. But again, that bucket only applies to non-US persons as well. The fourth category, some people have lumped this into the prior category because there's the foreign direct product rules. There's now 9 different foreign direct product rules. Again, I've been doing this a long time. We had the national security foreign direct product rule, that's been around since the 1950s. And now it's expanded to the Huawei foreign direct product rule, to the military and user foreign direct product rule, et cetera. Now there are 9, there's Russia foreign direct product rule. So these are 2 new foreign direct product rules. But the third new foreign direct product rule, and I'm using this as a separate category because this applies only to 28 listed companies in the rule that are already on the entity list. So we all know about footnote 1 that applies to Huawei. Footnote 4, there's a new footnote 4 that applies to these 28. Now again, this is a foreign direct product rule, so this applies to non-US companies who are using certain US origin software and hardware to produce chips outside of the US, and this applies to them.
Right. I'm glad you added that because I think, we say that our show is for trade nerds and normal human beings alike. For the normal human beings who may be listening, I think, this foreign direct product rule is, as Doug said, is just wildly complex, and there's now 9 versions of it. But basically what BIS is trying to get at is if you make a product outside the United States, but it is the direct product of U.S. technology or U.S. software, then you're going to be governed by U.S. export controls rules. If it's a certain type of product, if you fall within the parameters of one of these 9 new, foreign direct product rules, there was one in this new rule for advanced computing items. There's another for supercomputers, and Doug is talking about the last one where it only affects, it's a new type of foreign direct product rule that says if you make this product in a certain way that you will be governed by U.S. export controls. And in fact, with respect to that one, you'll almost always need a license to send it to any of the entities on the entity list.
Yeah. Yeah, exactly. So again, I've been, with Huawei since 2019. And then since that expanded to the Huawei specific foreign direct product rule, which was I remember exactly where I was. That was in August of 2019. I was on top of a mountain, and then the Huawei foreign direct product rule was issued by BIS, and even though I was on a mountain, my phone was working.
Was this Kilimanjaro or some other mountain, Doug?
This was Mount Rainier. In my tent on Mount Rainier. And the Huawei specific foreign direct product rule was issued by BIS, and that all these non-US companies who I work with are, captured by this. And it was like, oh, what do I do now? So let me just go back to so again, just to recap, the first one was these new ECCNs. The second was these the 3 in-use restrictions. The third bucket is these 2 new foreign direct product rules. The fourth bucket is this addition of this foreign direct product rule to the 28. And what is the fifth category? This is the new restrictions on U.S. persons. So again, this is unusual. U.S. persons have generally, it's not like sanctions where U.S. persons, wherever they are located, are restricted. In fact, there's, a U.S. person. There's no restriction on a U.S. person, for example, facilitating a shipment, to a party on the entity list, like Huawei, for example. So, as a lawyer, I can do that. As a non-U.S. person working abroad, they can do that. So BIS has not historically imposed restrictions on U.S. persons. So this is highly unusual. And this has gotten a lot of publicity in the press, which is that, and I think also caused a lot of misunderstanding as to scope, et cetera. And so what this does is this imposes a new licensing requirement on U.S. persons if they support or facilitate certain activities involving advanced computing and other applications in China. So again, but if you really delve into this, again, it's not everything. Again, it restricts the shipping or transmitting or transferring to those A, B, and C applications in China. Again, the logic, the DRAM and NANDs. So it's not everything, it's just those 3 advanced technologies. And then also the hardware application. So if you're a US person and you know that this particular facility in China is manufacturing semiconductor production equipment, then there would be a licensing requirement for that US person. So this is, again, when you delve into this, it's relatively limited. Now, BIS today at 5 o'clock Eastern time did issue these new FAQs, and they did address this. I don't think that the FAQ was all that helpful. They tried to be helpful. I don't think it's all that helpful. I think there's going to still need some clarification, but I have been advising some non-US persons as well as US companies so far on how to address this issue. But again, it is key because to know the scope of the limitation. So again, that's the fifth category. And again, but the unique part about that I should mention, it's not US items, it's prohibiting US persons from providing certain services to non-US items that are not subject to the EAR. So that's another important thing to remember. So that's another unique aspect of that. So those are the 5 aspects of the new advanced supercomputing rule that was issued by BIS.
That is really helpful. And I did want to kind of pause on the last one with respect to U.S. persons because it is so unusual. I mean, we're talking about products that are expressly not subject to the EAR. So they're not U.S. origin products that are in China, and they're not even subject to the foreign direct products rule because then they would still be subject to the EAR. And they're basically, BIS is telling U.S. persons, and it's kind of a little bit, I found it odd the way that they did this because they already had a rule, 744.6, that said U.S. persons can't do certain, really problematic things like participate in projects in certain countries that had nuclear end uses, that had certain missile end uses. And so the way that they did this rule was that they didn't actually prohibit directly U.S. persons from working in these plants or facilitating certain activities with respect to these super chips. They said, we're putting you on notice that your activities, and then they list these activities involving the chips, could result in some sort of military use, and therefore you need a license to do the following activities. And so it was kind of odd because, first of all, they didn't say they would result in the activities that U.S. persons needed a license to do or were prohibited from doing by 744.6. They just said that they could result in that, and therefore were imposing a license requirement. So it was kind of an odd rule in my view, because it didn't just directly come out and say, you can't do this or you need a license. It tried to use the construct or the architecture that was provided by 744.6 already, and then squeeze into that in a way I found a little bit weird and not quite a tight fit. Mm-hmm. But I'm not sure why they did that. I guess maybe they didn't want to create a new rule that would do just this.
Yeah, that's a good question. I'll see what I can find on that. But I talked to some of my friends at BIS, but that's actually a good point.
So it sounds like the FAQs came out today. Anything interesting in the FAQs that you wanted to talk about before we say goodbye to our listeners?
Yes, so that's a good question. So the FAQs, there's 5 pages worth. The most useful ones, I would say, are the first number question on the second page. This is very important because there is a term, semiconductor fabrication facility. It's used in this rule, and it says, does this term refer to the actual fabrication facility at the beginning of the process? In other words, where the technology node is created, or to an OSAT facility at the end of the manufacturing process. An OSAT is a outsourced semiconductor assembly and test. It's the back end. You have the front end and the back end is what it's referred to in the semiconductor world. BIS, actually, this is the most useful one. They said that a semiconductor fab is a building where the production at the restricted technology level occurs. Subsequent steps at facilities, such as assembly, test, or packaging, that do not alter the technology levels are not covered.
Interesting.
So this is very useful. So now a company can send, as long as, even if they're manufacturing, an OSAT is manufacturing or working on these technology nodes, they can still send equipment to those OSATs. Big.
Yeah, no, that is very big, because I know that rule in particular, there are more U.S. persons than I realized in China working in this industry, and I've seen a lot of questions from there in particular, including what is a fab facility, which is where a lot of these restrictions.
So that was a useful one. The other one is they made also regarding the term facility. They're asked whether or not what is the fab? So some fabs, that I work with have, they have one building, because these buildings are huge, and if they're going to do a new, more advanced node, they don't just retrofit it. It's not like they have the same production line. In many cases, they have to build a brand new building. So they actually say here in 2Q2, which basically says that if the new building, even if it's on the same campus, is not that covered, it's not a covered facility. So if it's producing a 28 nanometer node, and it happens to be next door to the 14 nanometer node, then that is not a covered facility. Now, obviously, you have to be concerned about diversion and the like, but that's another story. The other key things, they do talk about U.S. persons here. I don't think it's all that useful. All they do say it doesn't extend to, it does not extend to administrative or clerical activities. That's one interesting thing. And so overall, the other interesting thing was, this is a question I've been asked. I've asked them several times. There were some news reports about so-called licenses that had been granted to Samsung and some other Korean and maybe TSMC that allowed them to do certain things. But these so-called licenses were announced like 2 days after the rule. So they clearly were not licenses. So what turns out that they actually were letters, that they did send some letters to the major fabs around the world saying that you can continue to do certain activities for 1 year. And this is different than the temporary general license.
That's what I was going to ask. It sounds a little like the temporary general license, but it sounds longer.
But it's not.
Right.
It was a letter basically authorizing them to do certain things, to allow exports to China. So basically it does say BIS has issued authorizations in limited circumstances to allow continued operations in China. The company who received the BIS authorization should provide a copy of that to you as the seller directly, which is good.
Yeah.
And the holder of the authorization should jointly determine, meet the authorization in that particular letter. So I actually, so that's good. And I'm glad they made this more transparent than this pretty opaque, guessing, situation that we were in the last week or so, 2 weeks. But it's interesting. Somebody asked me today, well, what if I have an export that is authorized by this letter and I'm exporting it from the US to a facility in China that is legally authorized? What do I say on my electronic export information? So it's not detained by China, by customs or by BIS, because it's not really NLR, because it's under this RS control. There's no license number that you can include. How do you reference this? So this is an unintended consequence that they just really haven't thought through. And it does create some interesting practical issues.
Going forward, I think that this is going to be a topic that we're probably going to need to circle back on in a couple of months to see how it's playing out, because it is the subject of a lot of concern. So this has been incredibly helpful. I'm going to put the floor open to you if you have any last comments, and then we'll.
Yeah, obviously there's a lot here, and we could talk all day about this. One of the things that I think would be an interesting discussion for our next segment would be the enforcement. I've been asked about that by several people. How does BIS go to enforce this? That's a whole nother discussion that actually goes to your expertise as well in terms of on the enforcement side and your experience with that. But that's a whole interesting area that I would recommend for either a separate episode or a future episode.
That's a great way to end it, because we would love to have you back, and I heard that as a commitment to come back. So sometime in the next couple of months, we will have an enforcement segment on this, and I think it'll mention both that area of enforcement, and we can also circle back on some of the things that prompted this UVL rule, because I think that was an enforcement concern as well. But thanks for being here, Doug. It was great to have you, and now we'll have you back again soon.
Okay, sounds good, Tim.
Okay, take care.
Take care.
All right, stay sanctions free and stay out of the fab facilities, everybody. Take care.
Produced by Heartcast Media.